Sure, yes.
Thank you. It's for an extremely interesting presentation. I agree with a lot of this, especially the institutional approach to it, which I think is fruitful and very interesting. But I also think that there are limits to the institutional approach, and I had two remarks and two questions that I come to realize that they're sort of integrated. But the first one is that you said that you started from Roman law, right? As the basis of the legal form and the formality of presumably the Roman forms is the basis for predictability and all that. That seems to be a very Weberian concept, right? You know, his critique of common law as arbitrary, as based on custom and all that, which sort of landed him squarely in what is called the England problem, right?
Yes, sure.
That's where capitalism started.
Yeah.
It didn't start in France. Quite the contrary.
That's right. That's right.
France was, backwards country.
Yes.
But they had this Roman law tool, right?
Sure.
Which they didn't in England.
That's right. Yeah. That's right. That's a typical argument. One of the reasons we put Roman law in the center here rather than common law is because we want to address problems within the European Union, and the European Union is mostly dominated by continental law. I mean, Great Britain is the odd man out there, right? And if you look at the map worldwide, there's a lot of countries who are using the tradition of continental Roman law-based law. If you look in Asia, they all modeled Western Europe rather than the common law system, right? China, Japan, they all looked at Prussia, essentially, trying to copy that. That's one of the reasons we put that center stage here. But we also want to emphasize that while the Roman law and the common law have quite different approaches to the way they reason, I mean, Roman law lawyers like top-down thinking and reasoning by way of syllogisms, right? You have an abstract legal statement, then you have special cases, and you sort of subsume the cases under the general laws. Whereas in the common law tradition, people reason more by analogy, right? But really, there are similarities as well in results, and also within the Roman law tradition, you can't really work without analogy to precedent cases. It's impossible, right? And there are also attempts to systematize and to codify law in the common law tradition, because they are having problems with the number of cases just getting out of hand. So there are similarities as well, and also the basic concepts, property rights and contract, and having a central government using top-down command law is shared by the common law tradition, right? So what we're trying to focus on is what these two traditions share, not so much on the differences. But that will probably be a good question to ask Geoff Hodgson on Friday, because he's from Great Britain and he's very much into this comparison here.
Yes, but that sort of was only the precursors to my institutional remark about this, because there seem to be, if you take strong and weak states, depending on what you mean by strong and weak state, right? You can obviously have strong and predictable states, and you can have strong and arbitrary states, like Russia, for example. And of course, you have weak and arbitrary states. The puzzle seems, therefore, can you have weak and predictable states? And I think there's a case to be made for a weak and unpredictable state.
Do you have an example?
Not in an. If you're a die-hard institutionalist, that's an absurd position to take, right? Because institutionalism, to me, explains a lot, but it kind of leaves out the cultural dimension, right? And it has, although classical economics or the classical liberal economics has a hard time explaining or accounting for state variation. Institutional economics
and institutional thinking has a hard time accounting for cultural differences, level of trust, for example. That's that has been there before the institutions were in place. So, as if you take, for example, the welfare state, it would seem that a generous welfare state is dependent upon social trust. You cannot take a generous welfare state with paid leave and transport that to all countries in all cultures, right? So you can have a weak and predictable state if the level of social trust is extremely high. Then the state only has to be predictable, doesn't have to intervene very much.
Okay, but what would be an example for a state like that? Norway, okay. I see.
I
All right.
Lenient sentencing, lenient court decisions, soft state, never hard, never, it doesn't, it's encompassing, it's rule governed and all that. A state that has a lot of things to say, but it isn't very strong.
Yeah.
The state is a nice person.
All right, that's right. That's a very good point. Can I just reply to that, and then Matthias, maybe if you
reply to him too.
Yes.
We focus only on two components. We not focus on the how the accountability developed in history. This is the missing part who makes the story complete, Morten. It comes too.
What
The way to accountability is the development of democracy and to build this trust, what you explain here.
Yeah.
This comes too
Well,
in the next step. By Fukuyama,
Yeah.
three parts of this combination of are important to build this state. It's not only a question about a strong state, but how to build this accountability from bottom up to organize the people themselves in small towns and counties and so on. This is the story from the Western world too. But it's not the big history, not the story from Weingast and Norse or Acemoglu, why nations failed. This is a new story by Fukuyama, and it's standing opposite to this, and Hodgson will explain it too.
Yeah.
This is the interesting story behind too.
Yeah, but I wanted to make a different remark to your very interesting point here. We haven't explicitly taken into account culture here, but we're really trying to keep that whole approach, the whole model open to that. And by bringing in, for example, legal anthropology, where trust is a big topic, we think that the whole framework is open to questions like that, and the basic method that we're trying to use is a comparative one. So your comment could be turned into a question of a comparative study of states under that aspect. And we could look for other examples like Norway and see how they managed to achieve that. And see if these are typical examples. And so all I'm trying to say is I don't see a contradiction between the point you made and the approach that we're taking here, but we think it's open to accommodating questions like that, and those are important questions, of course. Once we get into a closer look at Europe and then making such comparisons across Europe would be probably very useful in planning further steps for integration if we want to, or maybe disintegration, whatever. But very important question, I think. Yeah.
Can I add 2 sentences to
Okay.
this? You mentioned a strong and weak state, and Fukuyama explicitly makes the distinction between well-functioning and large state. So he says that in order for a state to function well, it doesn't need to be large. There are well-functioning small states and not so well-functioning large states. So when we say strong state, we mean a well-functioning state, not necessarily a large state. I don't know if this exactly applies to Norway, but I
Sure.
imagine.
Well, according to all indices, Norway and the Scandinavian countries are, top in the well-functioning bureaucracy and
Yes.
corruption and all that.
Exactly.
And speaking of corruption, you had all these. You had this other slide as well.
Mm-hmm.
And the question, I think, is whether is low levels of corruption a result of a well-functioning institution, or whether is a well-functioning institution a result of low levels of corruption.
Mm-hmm.
Because I mean, it's not obvious which is the explanatory variable here.
Yeah,
Right?
I wouldn't really see that as a causal relationship there.
Okay. I thought you did.
No, I wouldn't see it. I think the point that we're making is that the whole phenomenon of corruption is one that is based upon these different two kinds of cultures. On one side, the legal culture, which is sort of in the most pure form codified Roman law, based upon abstract statements, and the way people relate to each other informally, in families, in friendship, in informal gatherings. It's a different strategies of behavior needed there, and they're sometimes in conflict with one another. And in that field of tension is that's where corruption as a phenomenon emerges. Right? As a contradiction between these two logics. So you can't have any corruption if you don't have a centralized state, because people just relate to each other by way of friendship and conflict. It's not a problem. Within a state, it becomes a problem because you're not supposed to recruit persons that you're related. I mean, you don't want to give the job to your uncle, but you want to give it to the person who is best qualified for it, right? And that's sort of a field of conflict here, and there can be different ways of dealing with that. And it will be a very interesting question to see how different countries are dealing with that, and how important, strong institutions are. What does it mean to talk about a strong institution? How do you achieve this strong impersonal quality? And that's, of course, connects to the Weberian Weber debate. Right?
There's other people also.
Sure. I'm sorry. Yeah. Sure. Who else? Yeah. Okay.
Yeah, someone to ask followed the same thing, because I also thought that this was interesting, but I also had this hard time with the strong state in terms of violence or strong state in terms of legitimacy, and yeah. But I would say with Norway, and this is to make the point that I agree with Martin that Norway is not necessarily a big state, but it's not necessarily a predictable state. I think that Norway also is a pragmatic state, and has a legitimacy as a pragmatic state.
Okay.
So I also think that sometimes the distinction between sort of the state and the market and the state and the people should be too strong, because Americans need a strong state. I think Norwegians have a more sort of common interest in society and in the government, so they don't need that big state. And I think that this kind of sort of reasoning is hacking here, the legitimacy, culture, civil society, and all these sort of aspects. I was missing that in your
Okay. Yeah, I have to think about that. Thanks very much for that comment. Okay, yeah? And then, yeah, sorry.
It's lovely to sit here in a busy week and finally get some sort of clarity. And then when the questions start, you wonder, oh, did I really see so clearly, or is it something that I missed? And there's lots of questions.
Okay.
But my main one, I think, is when you talk about the duality between the law and the economics and try to find a new paradigm, do you draw any normative conclusions for the box at the left here, the stateless societies? Do you think that you have some sort of agenda on what you should do with weak states, places that would have been defined as corrupt had it not been because they don't have any law to define it? What do we do with the Brixton pound, all this informal IOU?
Right.
Do you have any view on where you want to go?
We try not to have any normative agenda with that, because it depends on what you want to do, what goals you want to achieve. If you want to have, if you want to trigger development and want to have all these Western institutions, then you're probably going to have to create something like this kind of system. But if you don't want it, you don't need to have to. Nobody needs to do this if he doesn't want to, really. But of course, there are pressures, there are power structures, and so on. I'm just trying to say we're not trying to make this a normative model, but a comparative model. We're trying to compare and see what's similar between these two ways of relating to each other as human beings by way of a state and law, and without a state of the law, and just see how are they different, what's the same, and what can we see if we look at the world through that lens. That's the first step, and we're not trying to make any recommendations at this point. It's just
But
to
do
try.
you make some sort of qualitative evaluation of the different systems? You know, this
Not really.
functions better in terms of, no, nothing?
I try not to. To be honest with you, I try to just take a comparative perspective at first and not take any normative point of view, because also that would influence the research, I think. You know,
Is it possible to not do it?
it's a good question. It's not fully possible, but you can try.
There's so much heterogeneity there.
Yeah.
I mean,
Yeah.
there's not one way of being without a state.
No, I agree, and I think that's
So you
part
need
of
to
the
understand
really
that
rich
first.
potential of the things that what sort of questions do you actually want to ask,
Mhm.
because you have these other frames.
Mhm.
Wolfgang, where is China in this framework? It's not there. Maybe this not developed countries will follow the Chinese way, maybe. Is this a approach for them more better than the Western way? This is one of the
Yeah.
answers.
Where-
I would say
Where are
schematically it is in there.
sustainability goals?
It is in the private law area. It doesn't have constitutional law yet, China. China has a centralized authority, and it doesn't have the whole
China
rule of law.
has never in its history a rule of law. Never. You know
That's,
this from
that's,
Fukuyama.
that's what
Yeah.
I'm saying. But in the 1990s, they almost verbatim used the German BGB, the private law in Germany, and so they established in the 90s. They started in I think 78, establishing private law institutions, and they explode from 78. So this is a scheme. It's not. This is history. It's a scheme.
It's a lens. It's designed as a lens to make some distinctions, to take a new look at what's actually happening in the world as an alternative to the old lenses that we used, like neoclassical economics, which didn't make these distinctions. It's a universalist model, and presupposes things just happen the same way all around the world. And we're trying to make a distinction here by saying, when we're talking about this tradition of European law, of Roman law, that's a historically specific thing. It emerged, in history at specific points, and it doesn't exist all around the world. And so therefore we have to become sensitive to these other systems again, because Europeans, they started from that as well, but they tend to forget that. And so we have to bring that back into discourse. But you want it.
I guess I have one question and one comment, which is about what everyone else is talking about. So firstly, legally speaking, you seem to outline these two extremes, right? Where you have contract and consent on the one hand, and on the other you have kind of, forceful order.
Right.
And so this relates to what Sverre and Morten were saying about high trust and so on. So I wonder if there is an idea of a social contract, right? Where you have a kind of, if that's a mediating thing, where you could have contract and consent also within state authority. So I wonder if you could comment on the social contract as a kind of legal idea and how it pertains to this. And then
Sure.
What Marit and everyone was just talking about, I agree. I mean, I think, so you don't specify that this view is based on the European idea of the state. So it's quite Eurocentric without stating that it's Eurocentric. So perhaps you could make it explicit, Eurocentricity explicit.
Yeah, well, it's supposed to be a model of European society, right? And in that sense, it is Eurocentric. That's right. But we're not saying, all the world should be like that or all the world is like that. It's just, what developed in European history.
So my main question was,
Yes.
there is anything in between these two extremes, right? In between contract and consent and,
Right. Of course, the distinction between private law and public law is just an analytical distinction to make clear that conflict. But the whole idea of social contract, we would place within this area of constitutional law here, which is an attempt to subordinate the state as a centralized authority to the will of the free citizens, right? And to use the principle of contract to structure the form of government as well. So let me go back to the to the slide where we listed that, because I skipped that. Right here. So this, in European history, what developed to mediate this conflict between the private law and the public law area was, of course, the idea of republican constitutions, right? So the idea is to restrain the centralized monopoly of force of the state, but to retain it at the same time. So you don't do away with government altogether, but you subordinate it to the will of the people. In other words, you decentralize sovereignty from the top, from an absolutist ruler, a monarch, right down to the level of everybody, right? And that's called popular sovereignty. And that's one attempt to mediate between these two extremes here, right? And I mean, these are just a few basic principles that are used in republican constitutions to achieve that. And of course, we have the division of powers. We have 3 branches of government, the legislative, judicial, executive branches, to divide up that centralized monopoly of force and make sure it cannot be used arbitrarily, right? And we have the principle of democracy, which decentralizes sovereignty right down to the level of the individual citizens. And of course, we have the rule of law, meaning that the state itself has to be, or has to subordinate itself to the law created by the citizens. So you can actually sue a republican state, and you couldn't sue a monarch, right?
So this is really the history of the tax state. Goldscheid, Schumpeter would be a shortcut, perhaps, to understanding this development.
Sorry, could you?
Schumpeter
Yes?
and Goldscheid, 2 different articles on the history of the tax state.
Uh-huh.
Really have this in a nice short summary.
Oh, thank you. Okay. Uh-huh. All right. So, yeah?
Is there
Martin?
time for what? You have green as law and red as non-law. But what-
No. Red is the state and public law, and green is private law.
Ah, yeah.
That was the.
Sure, thanks.
All right. So, Ben, do we have time for one more? I think we have to move into the break, right?
Well,
We can continue in the break.
Continue the discussion and officially taking some coffee, and then in the meantime we set up Nicholas.
Okay.